Hello, my name is Tammy Flick, and I am a freelance graphic designer, brand designer, and illustrator, and you are listening to the GuildCast.
GuildCast is a weekly podcast series based on the 3 pillars of the Graphic Artists Guild: advocacy, community, and business resources. Keep listening to learn more about the Graphic Artists Guild and visit our website at www.graphicartistsguild.org.
But the problem for creators is, people who basically want to weaken copyright, want to make copyrighted works available for people to use as much as possible. They want this idea of fair use to be weakened enough so that that it falls more on the side of people being able to freely use things without worrying that it denotes copyright infringement. And of course, for creators, we want a much more strict interpretation of fair use because we want our works protected as much as possible so that, somebody can't just take our work and do something really minor with it and say, oh, yes, well, that's fair use.
GuildCast is brought to you in part by Graphic Arts Today. This week in advocacy, Rebecca talks IP court cases.
Hey, what's up, guys? Welcome to GuildCast, a podcast series by the Graphic Artists Guild that focuses on 3 pillars: advocacy, community, and resources. So now, this week, we're focusing on advocacy again, and we are back with Rebecca, who is our advocacy liaison, and we are going to be talking about IP court cases, but specifically ones that have gotten to the Supreme Court. So, Rebecca, as usual, we'd love for you to introduce yourself before we get into the details of what's up today.
Yeah, hi everyone. I'm Rebecca Blake. I'm the advocacy liaison for the Graphic Artists Guild. As you probably know, the Guild is really involved with advocating for visual artists. So what I'll do is I'll work on legislative issues or on issues that are before different courts. We often partner with other organizations and sign on to amicus briefs, which are friends of the court briefs, which kind of educate the court on what the ramifications are on different rulings on graphic artists, and that's what I do.
Awesome, and it's amazing work, and we appreciate you so much for that. In this specific episode, guys, we're gonna be focusing on, like I said, the IP court or IP cases that have reached the Supreme Court. So we're going to be focusing on the Supreme Court rules that the registration certificate must precede an infringement lawsuit. So that's one case we're going to be looking at. And these are actually featured as well on our Guild website. Another one we're going to be looking at is Oracle versus Google. The Guild joins amicus brief. And the Supreme Court rules no protection from state copyright infringement. So take it away, Rebecca.
Yeah, so that basically, that covers 3 really big issues that have come up before the Supreme Court. And it's really interesting because in the last year and a half, the Supreme Court has considered or is considering three major cases that could have a lot of ramifications for creators on copyright and intellectual property. And so usually copyright cases or intellectual property cases don't really come up before the Supreme Court that often. So we're in this really interesting period where a lot is happening. So we've been really engaged on that. So
yeah, I think it's really interesting, as complicated as it gets sometimes to understand all the details of, how everything works and the laws and stuff. I think it's really interesting, especially as more of a newbie, to kind of hear you dive into all of the details. Sure. So how about starting with the first one, the case
the registration certificate?
Right.
Yeah.
So, but before you get all the way into it, tell us a little bit more about what that means.
I certainly will. And it's really interesting that you'd ask that, Camille, because, the thing to take away is these arguments before the Supreme Court, become very esoteric. And I have to pull up a legal dictionary to read through each decision. But the thing that creators need to take away, especially graphic artists, is that, these decisions actually have ramifications on how we do our business. These decisions affect how we register our copyrights and how we can defend our copyrights. So, there's no way that we can expect people to sit there and read Supreme Court decisions, but that's where what people should do is, pay attention to news sources that deal with intellectual property, particularly news sources that are sympathetic to creators, because there's a lot of really good news articles out there that can really recap what the decisions are. And also, watch the Guild News, watch how we're reporting on it. We partner with a lot of other visual arts organizations, a lot of the really great photography associations like ASMP and PPA and NPPA and APA. All of these organizations also will report for their photography members on what the ramifications of these different cases are. So it really helps to kind of understand what's happening, because that's going to directly impact how you can register your copyrights and how you can defend your copyrights. So this first one, the Supreme Court rules that registration certificate must precede an infringement lawsuit. That's the name of the article on our Guild website. This ruling actually directly affects how people register their work, when they should register their work, and how and when they can sue a copyright infringer. So the background on this is, historically, if anybody who registers their copyright knows that it takes a long time to get your registration certificate. It's anywhere from a few months to, depending on if the Copyright Office has questions about your registration, it can take up to 18 months to actually get your little certificate that your copyright is registered with the Copyright Office.
100 years later.
Yeah. So historically, that's a long period where your work's going to be out there and people could be infringing the copyrights doing your work. So historically, what the courts have done is the courts have, they've looked at the date when you submitted your registration as the date of copyright registration, with the understanding that, that there is a time lag before you can get your registration certificate. So that means when you sue your infringer, you have to have already registered your copyright. So you get a little bit of leeway. If somebody infringes your work right away and you still haven't had that certificate in hand, there has always been this little bit of leeway. There's an understanding that you had submitted your registration. However, this thing happened. There was this dispute between Fourth Estate, which is an online news provider, and wallstreet.com. So Fourth Estate was producing these news articles on I think it was on finances, and wallstreet.com was licensing Fourth Estate's articles. So they had agreement. Fourth Estate would provide the articles, and wallstreet.com licensed the articles to appear on their website. The problem was Wall Street violated that agreement because they kept Fourth Estate's articles up after that license had expired. So, the license said you can have these articles posted for X amount of time. And when you get to that period of time, you have to, ask for another license to extend that period. Wall Street just kept kept the articles off. So Fourth Estate basically sued wallstreet.com and said, you're violating our copyright because you've kept our articles up after the license. Wallstreet.com took a look, and what they realized is, Fourth Estate writes articles. They write news articles. That means that if they're writing a news article, that article has to get up right away because it's news. So Fourth Estate was writing the articles, giving them to wallstreet.com to post, but also submitting the articles for registration, copyright registration. But because the news cycle is so short, The articles were being posted before they got their copyright registration certificate.
Right.
So Fourth Estate moved to dismiss their lawsuit, their copyright infringement lawsuit, because they hadn't yet registered their copyright, because they didn't get the certificate yet.
Wow.
And Fourth Estate basically responded that, well, look, this has been established practice. We submitted this for copyright registration. So therefore we should be able to proceed with this lawsuit.
Yeah.
But the court granted wallstreet.com's motion to dismiss. Fourth Estate appealed it, and that decision to dismiss was upheld on appeal. So then basically this case worked its way up to the Supreme Court. This is really, really crucial.
Yeah.
Because imagine if you're an illustrator and you're working on an editorial illustration to go up into some news publication's editorial page. That illustration. Yeah, that illustration's going up right away.
Yeah.
Or if it's an illustration for a news article or an infographic for a news article, that illustration, that graphic is going up right away. The whole point of the news is it's new.
So then my question is, isn't there, I mean, I don't necessarily want to take you all the way off topic, but isn't there something, I would imagine that there would be something or a different law or, amendments or something that would apply to people in that situation where the turnaround has to be immediate.
There is a process to do an expedited copyright registration, but it's extremely expensive.
No, I didn't mean like that.
This is not something. Yeah, this is not something.
I meant more along the lines of like how what you were telling us and telling me in the last or us, I guess, in the last one that last conversation we were having about the fair usage type of thing, where you get a leeway based on what the situation is. Like
there's no leeway. Yeah, no, there's no leeway when it comes to copyright. It's a very simple rule. When is your work considered registered for copyright? Is it when you submit the registration application, or is it when you get the certificate? Yeah. So the problem is the Copyright Office does sometimes reject a copyright registration. They may deem that a certain design or a certain illustration isn't copyrightable if the designer or the illustrator basically, just sort of stuck together two things that are in public domain that are not copyrightable. The Copyright Office is going to say this isn't original enough, so it can't be copyrighted. So there is a point to the fact that your registration really isn't secured until you get the certificate. I mean, there's a reason why this is an issue. But the problem for creators is it takes so long to get your registration certificate. So, when this went before the Supreme Court, the Authors Guild signed an amicus brief. And an amicus brief is a brief that is a friend of the court. And what the amicus brief says, the point of an amicus brief is to educate the court on what the possible ramifications of a decision would be on a certain group of people. Right. So the Authors Guild, which represents writers, did this great amicus brief where they basically said, if the Supreme Court rules that the registration is only valid when the actual certificate is received, it's going to have this deleterious effect on creators. Of course, the Guild signed on to that amicus brief. The Authors Guild invited all these other creators organizations to join their brief, which we happily did. And what that amicus brief said is, that there is rampant, immediate infringement of copyrighted works, and that continues to balloon even as registration processing times increase. So we've seen registration processing times have incrementally been increased as the Copyright Office has been overwhelmed with registration certificates.
Right, of course.
But what the Supreme Court ruled is the Supreme Court actually held that copyright registration only occurs after the Copyright Office approves the registration. This is not the outcome that we had hoped for.
Yeah.
But basically what this ruling says is you can only sue a copyright infringer after you get that copyright registration certificate.
Yeah.
Yeah. So this was it was not what we wanted to hear.
So just to clarify then, I mean, oh gosh, I kind of know the answer to this, but I feel like, can't they do, I'm just asking, but like, isn't there a time frame where they could say, okay, it's in registration, at least have some kind of different, parameters or something like in the registration period, as opposed to like, you register and you might get your cert, and when they've decided like, okay, we're going to give you the certificate, but you have this time frame for between when you have it in your hand. Like, I just find it so outside of logic to just not allow that to apply as well.
Yes.
GuildCast is a weekly podcast series based on the 3 pillars of the Graphic Artists Guild: advocacy, community, and business resources. Keep listening to learn more about the Graphic Artists Guild and visit our website at www.graphicartistsguild.org.
Yes, it is extremely frustrating.
Yeah.
But the problem is that raises a really big problem that puts a spotlight on the issue with how long it takes to have registrations processed. And so basically, a solution to this has to be found. Either it's a procedural solution in the Copyright Office, it may have to be a legislative solution, which has to come from Congress. What happened is Senator Tom Tillis of North Carolina and Senator Chris Coons of Delaware both sent a letter to the person who was the acting registrar of copyrights at that point, Karen Temple, and asking what steps the office is doing to reduce processing times. Now, what the Guild, through the Coalition of Visual Artists, has proposed, there are a number of really dynamic ways that the Copyright Office can reconsider how to handle registrations. And the Guild and the Coalition of Visual Artists has basically asked, and we put this in numerous comments to the Copyright Office, to consider a dynamic solution. For example, what if you as a creator were able to submit a registration but not have the Copyright Office examine that registration? It's a pending registration.
Yeah.
And then, so it's a pending registration. Then when your work is infringed, you then submit a second fee to have that registration considered on an expedited basis so that you can proceed with an infringement lawsuit. The reason why that could be a possible solution is it would take the burden off of having to examine all of these registrations at the outset by the Copyright Office. So this is one of the dynamic proposals that we made. But there is no easy fix right now. So what we're urging graphic artists to do is just proactively register your work. See, when it's finished, but before you deliver it to the client, before it's been published, you can register it as an unpublished work. So that's one possibility that you have. Get your work registered as soon as
crossing the T's and dotting the I's I guess solution better than cure, or prevention better than cure.
A larger cure to the problem of processing times is going to take a long time to come to fruition, because it involves modernizing the registration process. It involves lots of different moving cogs that need to work together. The short-term answer is to say to creators, register your work early. Register it early.
Take charge of it.
Yeah, and it also means, unfortunately, that you can't bring that infringement lawsuit until you get the registration certificate. So the earlier you register your work, the sooner you can bring that infringement lawsuit.
Definitely.
Yeah.
So, okay, that makes... That sounds like a decent fix, especially because, like, as you're saying, all I can think of that would help with any of that is, the Copyright Office themselves getting more work. So to me, that sounds like a good way to kind of balance the two.
Well, it's a balancing act because there's also an issue of the Copyright Office needing more funding.
Oh, sure.
The Copyright Office isn't delaying registration certificates because they're,
bored.
The Copyright Office is working terrifically hard to process registrations. The problem is that we need funding allocated for the Copyright Office. All funding for the Copyright Office goes through the Library of Congress. And the Library of Congress determines how much the Copyright Office gets. We support the idea that the Copyright Office gets dedicated funding. Yeah. That Congress provides dedicated funding for the Copyright Office, that the Copyright Office have autonomy over their budget. Because when it goes through the Library of Congress, the Libraries of Congress, they have a pretty broad agenda. And copyright,
of course,
dealing with copyright issues is only one piece of that. But for creators, copyright registration is so imperative to defending our copyrights. Yeah. So really a bigger answer is, how can we make sure that the Copyright Office is properly funded? And how can we make sure that the Copyright Office is able to modernize the registration process? This registration process dates back to pre-internet, and it's been modified for an electronic registration system. Yeah. But it's not the dynamic, state-of-the-art 21st century approach that it needs to be. There are so many smart ways that we could make registration easier and ultimately cheaper for creators.
Definitely agree. I would love to see that happen very soon, but we're going to be crossing fingers until then. But I mean, what I was thinking about a while ago is that it's crazy that the types of, people that get into these, I guess, disagreements, because you were just talking about Wall Street, and it's like, you don't. It's kind of sad to just think about the fact that they're kind of, I guess, exploiting their.
I need to be really clear. WallStreet.com was the name of the publisher. That's the name of the publisher. That doesn't have anything to do with Wall Street itself. So it's a mistake to think that every corporation or big business is against copyright. That is not an issue here. WallStreet.com was only the name of the entity that was republishing the works. It's not a reflection of big business or Wall Street as a concept.
Well, I just meant in terms of it copyright affects everyone.
Yes, it does. Yes, you're absolutely right.
That's where I was thinking of.
That is a really good point to make. People often think that copyright only benefits big corporations like Disney, multimedia. No, you're right. And I know you know this because you're a songwriter. Yeah. Copyright benefits individual creators. It benefits individual artists who are, sort of working away at being designers and illustrators and photographers and songwriters.
And the little ones all the way to the big.
The little ones. It's us individual creators that we're worried about, and that's why we need strong copyright protection for us.
So tell me that I was looking at the other case and thinking about just...
Are you looking at the
I'm like, what
versus Google?
Yeah,
and you must be wondering about this one. Why on earth does the Guild care about Oracle versus Google?
I'm ready to hear it. Let's go.
Well, this is an interesting case. Yeah, and we get that question. Why do we care about Google versus Oracle? So this case is before the Supreme Court. This is an interesting case. It's been characterized as the copyright case of the century.
Wow.
So at issue is whether the Java APIs are copyrightable and whether Google's use of the code falls under fair use. That is the reason why the Guild is involved, because this case speaks to fair use.
Fair use. Mm-hmm.
And fair use. So just to recap, fair use is the concept that under certain conditions, the use of copyrighted work is fair and doesn't constitute infringement. And the idea of fair use is, you can't lock up every single copyrighted work into a silo where nobody can ever touch it, because that's going to have ultimately a deleterious effect on society and on innovation. So the idea is, under certain circumstances, for example, in an educational situation, teachers should be able to use a copyrighted work to be able to educate a classroom. So, the teacher should be able to photocopy a short story in a book to hand to the class for the class to be able to read. That's one idea of fair use. Another
I used to wonder about that in school. Like, you just photocopy.
Another carve out for fair use that is important for graphic artists is parody. You can use something to make fun of itself, and that falls under parody because you're basically commenting on that thing. You can use a copyrighted work in commentary. If you're writing a news article about, about a book, for example, you can quote from the book to in the course of your review. You can't publish an entire chapter of the book, but you can comment, you can comment on excerpts of the book. And another area which is important to graphic artists is transformation. People do incorporate works that are copyrighted in the creation of a wholly new original work. Well, not wholly new, but in the creation of an original work. And transformation is really, really tricky, because the work you have to be created, it really has to have new meaning, it has to have a high degree of originality. You can't take a photograph and trace it and then do a pretty watercolor and say, well, that's transformative enough. That's not transformative enough.
Right. Let's make it black and white.
So when it comes to fair use, the whether or not your use is fair falls into a gray area. You need to really understand how you're using the work, and have a basic understanding of fair use. But the problem for creators is, people who basically want to weaken copyright, want to make copyrighted works available for people to use as much as possible. They want this idea of fair use to be weakened enough so that that it falls more on the side of people being able to freely use things without worrying that it denotes copyright infringement. And of course, for creators, we want a much more strict interpretation of fair use, because we want our works protected as much as possible, so that somebody can't just take our work and do something really minor with it and say, oh yes, well, that's fair use. And that's why fair use is so important for creators. And that's how we got interested in Google versus Oracle. So you ready to hear why a fight between technology? Okay, so here's the deal.
Love it.
Here is the deal. Way back when Google was developing its Android operating system, it wanted to use this Java programming language. Java was really popular with developers. The Java platform permitted developers to write a program on one operating system and have that program run on a different operating system. And Google specifically needed the Java API. An API is an application programming interface that permits handshakes between different applications. They wanted use of the Java API in order to develop the Android operating system. So Java at that time was owned by Sun Microsystems. And so Google started negotiating with Sun Microsystems. The negotiations didn't go anywhere. So instead, Google integrated Java's part of Java's code is called the declaring code into the Android system, and then wrote its own implementing code. So they took a bit of the Java code and then they wrote their own little bit of code to make it work. And that permitted developers to develop their own Android applications, but using these really familiar Java declarations that made it work beautifully cross-platform. So in 2010, Sun Microsystems was bought by Oracle, which meant Oracle now owned the copyrighted to Java. And Oracle also continued to develop Java and continued to pursue licensing opportunities for Java. So Oracle sued Google for copyright infringement. Yeah. And then they sued in a district court, and the original lawsuit was dismissed because the district court said that APIs aren't copyrightable. Oracle appealed that decision. The U.S. Court of Appeals found that APIs are copyrightable. That led to a second court case to determine if Google's use of the API fell under fair use. Oracle lost the case again. They appealed. The Court of Appeals ruled in favor of Oracle's. DMLA issued an amicus brief in that case that we signed on to. And this time, the U.S. Court of Appeals ruled in favor of Oracle, and Google petitioned the Supreme Court. So, the Guild participated again in another amicus briefs in support of Oracle. What we're really worried about is the description of transformative. And this is so crucial for creative articles. So the amicus brief that the Guild signed on to addresses this issue of transformative use. So what it basically says that fair use has been applied really unevenly in different court cases. There's really not a great consistency in how court cases considered fair use. And the concern is that several court decisions have extended the idea of transformative use beyond the extracted construction of new expression, meaning, or purpose. And that is at the core of transformative use in fair use. So this is a Supreme Court case, involving two tech giants. That sounds like, why do we care? We care because it speaks directly to fair use, and we care because it also speaks to the interpretation of what does transformative mean.
Coming up on this episode of GuildCast.
So to understand state copyright infringement, what we're talking about is we are talking about states in the Union. We're talking about individual states like North Carolina, New York, Texas, California, basically taking copyrighted work and using it and declaring sovereign immunity.
Join the Graphic Artists Guild to listen to the full version of this episode at www.graphicartistsguild.org. Thanks for listening to GuildCast. Coming up in next week's episode.
So I say to my students, figure out what it is that you love the most and focus on that area so that you can start attracting the business in that area. And I use the example of this one student who I had who was an avid bowler. Now, I know nothing about bowling, but he was always talking about it. Bowling scores all the time, every time he came to class. And he really picked up on web design, and he really liked the coding. And I said, Brian, you could be the bowling website guy. I mean, that you could create a niche market for yourself and not just focus on one geographic area, but be, the bowling website specialist for the United States and beyond.
GuildCast is a weekly podcast series based on the 3 pillars of the Graphic Artists Guild: advocacy, community, and business resources. Keep listening to learn more about the Graphic Artists Guild and visit our website at www.graphicartistsguild.org.